Here's the legal frame you should lock in. Judges don't just feel bonds, they balance them. Two prongs rule the room. One, is the defendant a danger to the public? And two, if released, will he actually show up where he's wanted? That second piece matters even more in fugitive contexts, because another county here, Orange County, is waiting to retrieve him. Practically, if she sets a bond, he could walk but. Will he walk into the next courtroom like he promises, or disappear, like his paperwork suggests he's done before? Audience, tell me, should prior conduct on paper outweigh what sounds like sincere remorse in person?
Sir,
How's jail?
I had, but I put
Apparently
myself
it's good because you're laughing and you're in great spirits.
Sir, I put myself in this predicament, so I gotta.
Well, at least you can recognize that that's a good thing, you know? So you were wanted out of Orange County for a DWI,
Yes, sir.
and now you've picked up another DWI here in Harris County. Your lawyer,
Apart.
I'm sorry?
They're about 5 years apart. But I know.
So you've been gone for 5 years
Good,
and you want me to set you a bond?
sir.
So you here because you're wanted out of Orange County. You're now being here held in Harris County at 0 bond. So we have you here out because your lawyer is asking me to set you a bond.
Yes, sir.
Because otherwise what happens is you sit here in custody until all of your cases are done here. And then we wait for Orange County to come bring their happy selves over here to pick you up.
Yes, sir.
A lot of times, me as a judge will set a bond on a fugitive case if I.
This is where the paper trail crushes the "I've changed" narrative. The prosecutor maps it out. January 2023 Orange County warrant. October 2023 new Harris County DWI. 2 months later, bond forfeiture. Then he's picked up and charged with failure to ID by giving false information, whether it's 13 or 133 failures to appear. The theme the state's selling is pattern flight, deception, and drinking and driving after a warrant is active. Viewers question, does a clean job title "I'm an offshore engineer"
feel that the person is not a danger to the public, because that's my main concern. 2, are you a danger to the public? Number 1. And number 2, if we set you a bond, are you actually going to go to the jurisdiction that wants you? Therein lies the rub. That's the question for you. But I know that what you're going to tell me now, it's like little bunnies jumping in the woods. Yeah, right. But it's what's on paper to me that matters, because what's on paper is the person who you truly are. Mr. Kim, tell me about Mr.
The warrant from Orange County was issued out on January 2023. Between that time and being apprehended today, he was again charged, or he was charged with DWI on October 2023, in which he bond forfeited 2 months later and was apprehended again when he was simultaneously charged.
The judge's little bunnies in the woods line is more than Sasset's judicial PTSD from hearing the same redemption arc on loop. Defendants promise the world, dockets tell another story. The accused counters with specifics: offshore, work, lawyer appearances, reinstated bond, and a promise to show in Orange County. Smart move. He reframes himself as a structured adult, not the reckless college kid of his priors. But here's the reality check. It's not the speech, the spreadsheet. Judges trust verifiable compliance, not heartfelt monologues. Would you buy it?
For failure to ID, giving false
Wait, is that here or over there?
here. So he had a DWI or DUI in Orange County. While after that warrant was issued, then he picked up a DUI here, and then he bond forfeited the Harris County DUI, and then he was picked up 5 months later and was also charged with failing ID by giving false information, and then obviously bond violating the DUI. I've shared with counsel in other states he has a failure to appear at least 13 times and evading.
Oh,
I believe he's the definition of a flight risk.
Sir, I was young. That was years ago.
how old are you now?
I'm 28. I'm an engineer offshore. I got my ducks in a row. The DWI here, it was a miscommunication, and I showed up in court to the lawyer after I failed. She said I failed to appear. Me and my lawyer showed up in court and explained that it was a miscommunication. She reinstated the bond. We're back on good terms with everything. I think I have a court date coming up soon for that. My lawyer, she said I no longer have to show up since I work offshore, so my lawyer's gonna show up for me. So this is the only thing that I have. Those other cases, when I was a young college student, I got my stuff together now, Judge. I promise you, like, I am not a flight risk or anything like that. I take my life very serious, and I'm not just talking. I'm speaking from the heart.
Little bunnies jumping in the woods.
Boom, that one line blasts through every give me a chance plea. Importantly, the judge then references 13 FTAs a decade ago. That's a factual pivot you can't ignore, especially after the state floated a far higher number. But the judge's underlying reasoning still lands. You just forfeited bond on a fresh DWI 5 months ago. Translation: even if the past is foggy, the recent record is crystal. Here's the ethical tension for our audience. Should a person's recent attempt to self-surrender and fix a miscommunication
Definitely not. Most definitely not. And if I am able to bond out, I will
Ask you
show up
this.
in Orange
If
County.
you were the judge, would you give that person standing in front of you a bond?
Yes, sir. Only I would love for you to. I'm going to show up out there. I've already talked to my mom and everybody. I'm showing up. If you give me a chance, or I promise you, I will not disappoint you.
Not even Jesus himself could convince.
This is strategy, not cruelty. The judge briefly floats a $150,000 bond, then withdraws it, concluding that any release would be enabling. Legally, a bond is supposed to ensure appearance and protect the public, not become a revolving door. By keeping him at zero bond on the fugitive hold, she forces jurisdictional handoff and cuts off the risk pipeline. Viewers, is this tough love or judicial overkill? Drop your take, especially if you believe structured high bonds can be a middle ground.
And I don't want that to happen to Mr. Grimwade, but at some point you got to get it. And for me, if I were to give you a bond now, I would be enabling your behavior. And I would say, yeah, it's okay for you to do this, when it most certainly is not. Especially in light that you have a DWI over there, you've got now a DWI here. It's as bad as it gets, man.
They're years apart.
New defendant, new disaster class. Mr. Wright is on bond for a felony. Picks up possession of marijuana, and brace yourselves, drives without a valid Texas license. The judge's reaction: surgical sign and affidavit promising no driving. Or get ready for 6 months in jail and a $500 fine every single time you violate. This is classic graduated sanctions, not locking him forever, but making the next bad choice so expensive he feels it. Question to you: should every bond include a month?
How's jail? Good. I hope it's an absolutely miserable experience, because we're not getting through to you. What do we need to do to get through to you that you have to follow bond conditions? You now have picked up a new case while you're on bond for a felony. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000.
This is the compliance blueprint you don't often hear spelled out this clearly. Twice weekly drug tests, AANA, 3 times a week, proof filed every time, a 9 p.m. curfew, full-time employment, no driving, no drugs, no alcohol, and the sword of 180 days contempt, plus a minimum 9-month in-jail treatment program hanging over every slip. Translation: freedom, but only if it's structured, measured, and verified. If you're rooting for rehabilitation, this is the judge putting her money where your mouth is. If you think he can't do it, say it now, because she literally tells him, don't take this deal if
So maybe we should keep you in custody and put you in a rehab then.
I tried going to the Texas house. The last one I got rehab to, the one I got sent to before rehab was the Texas house. That was a year-long program. Had a really short, really low percentage of graduating. I made 6 months the first time and 10 months the second time. I got scared. I went back to where I came from last. I don't need to go back to, I just want to, I already know there's a really good record at the Bill House over there on Deer Park, right down the street from the police department. I have a friend of mine that just went through it. He's had these same issues as me. As far as drugs are concerned.
You're not giving me much confidence, Mr. Wright.
I want to get past this.
I don't think that you can do it on your own. You've already shown us that you cannot. Tell me again, why would we let you out? What do you think?
Give him a chance. Next he won't get another chance.
The only way you will get a chance from me, Mr. Wright, is if you come here 2 times a week and take tests showing me that you're not using anything, and you go to AA or NA 3 times a week with proof that you're doing it. I will give you a curfew of 9 p.m. and you must maintain a full-time job. If you want me to let you out, those are the things that you must do. And you must take an active part in sobriety. 3 times a week, I want you to bring me proof that you're going and doing NA classes. A piece of paper, that date, name, sponsor, and where you had the location and where you went to go do it. But I want proof every other day that you are going to NA classes, and you will take drug tests 2 times a week to prove to me that you're not consuming anything.
buckle up. 2 counties, 2 DW is a 0 bond hold, and a judge who flat out says, not even Jesus himself could convince me. In today's courtroom, Mr. Greenwade walks in asking for a bond while carrying a history that the state says includes triple-digit failures to appear, yet later the judge references 13 FTAs a decade ago. Confused? You should be. Add in a brand new Harris County DWI after an Orange County warrant, a bond forfeiture, and even a false ID charge. Then plot twist, we shift to Mr. Wright, who's on bond for a felony, racks up a marijuana case, and still drives without a valid Texas license.
Okay, Mr. Wright, you know what's expected of you. No driving, no alcohol, drugs, NA, 1 AA 3 times per week.
Professional summary, Mr. Greenwade, no bond. The judge decides releasing him would enable repeat behavior, especially with a fresh DWI, a bond forfeiture, and conflicting but still damning FDA histories. Public safety and reliability trump. Remorse, Mr. Wright. He walks but on a razor-thin leash, twice weekly tests, triple-week AA-NA curfew, full-time job, and 0 tolerance for driving or using. 1 slip equals months behind bars in treatment. Bigger takeaway. Modern judges are increasingly mixing accountability with structured rehabilitation. If you want mercy, you must accept monitoring. Your turn. Who did the judge get right and who? Did she get wrong? Should Green Wade have gotten a high bond with GPS, or was 0 the only safe call? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.